It's my pleasure. I'm Lou Mulligan, for those of you who don't know me. Come on in, Mike. Professor here at the law school, and it's a privilege of mine to introduce Dr. Tom Biesecker, who is here as our inaugural Schuchardy and Bacon Center for Excellence in Advocacy Fellow. There's a lot to say, but it's a little bit about the center. The center is a result of a very generous gift from a group of our alumni at the Schuchardy and Bacon firm, where they've contributed to project out their role as some of the preeminent trial lawyers in the country and to bring some of that training and skills back to KU law in a number of different ways. So some of the courses that Suzanne Valdez teaches in the Deposition Skills Project, where we do those practical skills-based intensive trainings, adding more courses there, to then a new series now we're going to bring in fellows from outside the law schools, whether at KU or other places around the country, to provide us with some empirical insights from other studies into best trial practices and how you can improve yourself both as a student and as a litigator. So with that, we're excited to have Dr. Biesecker be our inaugural fellow. He is a member of the American Society of Trial Consultants, a member of the board there. He's long made a study of jury decision-making here at KU in the Department of Communication Studies, where he's worked on how jurors infer missing facts, how they reconcile inconsistent facts when arriving at verdicts, among other things. He's been a long time jury consultant on how many? Numerous trials. Lost track of many. So today he's going to speak to us about the role of narrative in the courtroom. So if you help me welcome Dr. Biesecker.
Thank you very much. It is indeed an honor for me to be designated as the inaugural fellow. I have the greatest respect for Schuchardy and Bacon. Have known many of the partners who are there for a number of years. Have known most of the law faculty for a number of years as well. As a matter of fact, spent a semester down here, I don't know, a long time ago now. Let's just leave it at that, as an inter-university fellow. So all of this feels just great for me to come back and for me to spend some time talking with you about narrative in the courtroom and begin a process that will go on hopefully for the year. What is a lawyer's primary goal when in court? This rather straightforward question usually generates an equally straightforward answer. According to evidence scholar William Twining, it is to persuade the tribunal to decide, in this case, in favor of his or her client. In other words, the advocate's goal in the courtroom is to win, to obtain a victory favoring your client. Sounds simple enough, but how? Is there an approach to the task or a strategy that can increase the likelihood of success? Over the past few years, the answer to this question, given by many practicing attorneys, trial consultants, and researchers from the social sciences, has been a single word: storytelling. For example, Robert Wells, a practicing attorney in Kansas City and an alumnus both of KU Law and the Communication Studies Department, wrote the following in his treatise, Successful Trial Techniques of Expert Practitioners. In the typical trial, uninformed jurors are bombarded with an overwhelming mass of facts and legal concepts and are then asked to form a decision. In order to be successful, the lawyer must integrate this massive information into a coherent whole that can be understood easily by the jurors. This is best accomplished by using storytelling or narrative structure. David Ball, a nationally prominent trial consultant, echoed this sentiment in his book, Theater Tips and Strategies for Jury Trials. Good storytelling is the most powerful persuasion technique you can use. Stephen Lubay, professor of law at Northwestern University, added in his treatise, Modern Trial Advocacy, trials are held in order to allow the parties to persuade the jury or judge by recounting their version of the historical facts. Another name for this process is storytelling. So storytelling is the answer. But why? Why is storytelling given as the answer by so many? What is it about the storytelling process that could make it particularly persuasive when used by courtroom advocates? Several different but related answers have been given to this question. First, storytelling is a natural human activity. We grow up with stories all around us. David Ball comments, we hear, see, and read thousands of stories per year. When we relate our experiences to others, we do it through the use of stories. Ask someone, what happened this morning? You'll get a story. Ask someone else, why did you resign from your job? You'll get a story. Stories are ubiquitous. They organize our experiences. They help us create order out of sensory chaos and structure what we perceive so that we can make sense of physical events and others' actions. Because stories are so commonplace, each of us develops a repertoire of stories based on our past experiences and socialization. This stock of stories reflects our views of how the physical world functions and how people relate both to it and to each other. For example, most people know the story about the Good Samaritan, how it illustrates each person's responsibility to help others. How about the story of the ant and the grasshopper, the virtues of industriousness and frugality? Or the story of Barack Obama's upbringing, how someone from any ethnic background can succeed and become president of the United States. Each one of us has our own unique story repertoire reflecting our upbringing and our life experiences. This repertoire shapes both our behavior and our interpretations of what we see others do. In other words, we rely on our stock of stories to compare and evaluate new things or events that we encounter. Our stock helps us simplify and structure what otherwise would be cognitively unwieldy events. It allows us to infer causes for actions and to infer human motivation which bind together groups of facts. Now, let's apply these reasons to the jurors, or for that matter, the judges' task as decision makers in the courtroom. As Bob Wells pointed out, during trial, jurors are presented with potentially voluminous quantities of information called evidence. This information comes from multiple sources, primarily witnesses, and may be presented over days, if not weeks. The information is presented in potentially challenging ways for jurors to comprehend. Witnesses answer specific questions from attorneys. They don't typically provide a cohesive narrative. In fact, they may be instructed not to if their answers go beyond the boundaries of the questions asked. Certainly, they will not provide much narrative during cross-examination. Different witnesses provide evidence about different parts of the dispute, often not in a strict chronological or causal order. Most witnesses with direct knowledge of the dispute, fact witnesses, are not allowed to speculate beyond their recollection or about participants' motives. All of these factors present challenges to jurors which they address by employing stories. Reed Hastie and Nancy Pennington have hypothesized that in order to cope with these challenges, jurors impose a narrative story organization on trial information. They presume that jurors engage in active, constructive comprehension process in which evidence is organized and elaborated and interpreted by them during the course of the trial. In other words, they argue that jurors are active, cognitive participants throughout the trial. They listen to evidence, they organize it based on a narrative structure, and then evaluate the resulting story by comparing it with stories from their past. If Pennington and Hastie's hypothesis is correct, and they have supported it with more than 15 years of relative intense research, then courtroom advocates must understand how believable stories can be constructed, what factors increase a story's persuasive power with jurors, and the manner in which jurors compare the stories they hear in court with those that they have accepted throughout their lives. It's these questions that I want to address today. What is a story? Twining adapts a definition from Recur. A story is a narrative of particular events arranged in a time sequence and forming a meaningful totality. Thus defined, the story must include a set of elements. These elements, or facts, comprise the bits of knowledge available or selected as relevant about an event. Let's look at a very simple example. This set of elements as presented is a jumbled mess. As you read down the list, obviously some elements belong together, but the nature of their connection is not immediately obvious. In other words, this set of elements as presented does not yet conform to what we perceive to be a story. It lacks the second feature of any story, a sense of structure. Let's try again. For anyone quickly comparing, we've got exactly the same 17 set of elements. The wording of each element is the same. The only difference between the two versions is the order in which the elements appear on the list. This new order imparts a sense of structure, and by so doing, it increases the element's overall interpretability. With this new structure, we now have what most people would recognize as a very simple story. In other words, in order for a set of elements, or in courtroom terms, a collection of evidence, to be perceived as a story, it must be organized in some way that the individual elements or bits of evidence fit together in a pattern recognized by the receiver or juror. Pennington and Hasty comment, stories involve human action sequences connected by relationships of physical causality and intentional causality between events. In its loosest form, a story could be described as a causal chain of events in which events are connected by causal relationships of necessity and sufficiency. Formally, how different types of causal relationships operate has really not been well defined. What is important is that according to Pennington and Hasty and other storyteller proponents, each of us has an intuitive grasp of what they are. And we can distinguish between structures we consider proper or improper, normal or absurd. Now, what we have now is a very loose concept of what constitutes a story. So said in the courtroom context, what makes a story persuasive? Let's consider several more specific questions. The answers to these questions, when taken as a set, can help us assess a story's potential persuasive power with jurors. The first question is the evidence included in the story sufficiently detailed to support the conclusion drawn? Let's return to the very basic story I presented just a moment ago. If you were asked to decide who or what was responsible for the family tragedy described, would you feel comfortable making that decision based only on the information I showed you earlier? If not, what additional facts might you want? More information about the lane configuration of Highway 71? The road conditions on the day of the collision? The weather? Whether the traffic was involved in any way? Whether Mr. Martin had been distracted in any way? Were the kids fighting? Was he concerned about his job or his marriage? In what lane was he driving at the time of the collision? Had he changed lanes right before the impact? Had he changed speeds? In what condition was the truck that he was driving? Oh, and one other fact that is quite often kept from the jury: who among the Martin family were wearing their seatbelts? These additional facts are things that we might want to know. We could, and we will, a little bit later, add even more. And obviously the set of facts that was up on the screen includes a very limited amount of specific information. However, it might contain enough for some jurors to come to a verdict. The driver of the other car was speeding, and he was drunk. Therefore, he must have been responsible. Note that neither of the two claims I just made are facts in the story. Neither of the claims I just made are facts in the story. They both reflect inferences made from the facts. And these inferences are what might enable someone to assign responsibility. Let's consider a second question. Can the story account for all evidence presented by both sides? In order for a story to have maximum persuasive power, it must be able to incorporate all or virtually all available evidence within its structure. To the extent that some facts must be ignored, declared irrelevant, or swept under the rug conceptually, the story is likely to be less compelling. Let me change examples. Suppose you're defending a medical laboratory from a claim that it improperly conducted a medical test and as a result reported that a patient did not have a bacterial infection when in fact an infection was present. Your story would probably focus on the appropriate temperature for a sufficient number of hours and then carefully analyze the resulting culture. You would need to document the procedures the lab employed, the times when they were done, the qualifications of the lab technicians, and that all of the equipment was used in this process was properly calibrated and functioning. Now let me introduce some additional facts. According to the lab's record, the specimen was incubated for 48 hours. You have expert testimony stating that had any of the bacteria in question been present in that specimen, it would have been detectable by that time. However, here comes a new fact. The Centers for Disease Control, CDC, had earlier issued written guidelines that the incubation period for this test should last a minimum of 66 hours. Now you have a problem. Clearly, the lab's procedures were not in compliance with that CDC guideline. And the lab's basic story now cannot account for all the facts, and perhaps we could say cannot account for a critical fact. Its persuasiveness with jurors may well be diminished. This is one potential story problem. Let's consider a closely related question. Can the story accommodate any inconsistent facts that emerge at trial? Here I'm referring to contradictory statements made by witnesses or reported facts that both simultaneously could not be true. Again, an example. A doctor testifies she explicitly told her patient about the risks of surgery and provides as evidence of the conversation an informed consent statement with the patient's signature. The patient testifies that he recalls having a discussion with the physician, but that the discussion did not include anything about surgical risks. And the patient also testifies that at the time of the discussion he was already deeply sedated and in no condition to make an informed decision. These two bits of testimony obviously contain directly contradictory information. This contradiction must be reconciled somehow by either side's story if one or the other is to be seen as persuasive. There are multiple ways in which non-fitting or inconsistent facts can be incorporated into trial stories. Listing them and discussing them are actually beyond the scope of today's presentation, but vital during any trial preparation. Suffice it to say that for a story to be persuasive to jurors, it must be able to account for all, or at least the overwhelming majority of critical facts presented at trial, and it must deal with apparent factual inconsistencies. Jurors will recognize extraneous or inconsistent facts when they exist, and they will resolve them in some fashion on their own if necessary. Next question. Does the story conform to reasonable or realistic assumptions about how and why people behave as they do. Pennington and Hastie refer to this feature as a story's plausibility. According to them, a story is plausible to the extent that it corresponds to the decision maker's knowledge about what typically happens in the world and does not contradict that knowledge. We all have expectations about how different kinds of people respond to situations. We expect mothers to love their children and to protect them if at all possible. We expect accountants to be risk-averse, corporations to be driven by profit, drunk drivers to drive unsafely, people in general not to risk their lives needlessly. Stories that violate these assumptions are, at least initially, less persuasive. Again, an example. An admittedly very drunk driver was traveling down a two-lane road at night. While in his lane, he collided with another car turning left in front of him. As a result of the collision, he suffered severe permanent injuries. Now, his story was that the driver coming toward him suddenly and without signaling turned left into his lane when it was too late for him to stop. In other words, the other driver failed to yield the right-of-way, thus should be held responsible. Believe it? Based on just what I told you, would this story be persuasive? What if I told you that the other driver's story was that as he started to turn left, the drunk driver's vehicle suddenly breasted a hill traveling at a high rate of speed. Once he saw that vehicle coming, he tried to complete his turn, but it was just too late. Okay, which of these very abbreviated stories makes more sense? Now ask yourself the question, how much do your expectations about the driving behavior of drunk versus sober drivers play in your assessment of these contradictory statements of fact? People's assumptions about how others behave emerge from lifetimes of experience. Different experiential backgrounds yield different behavioral expectations. In this example, people's experience with alcoholics and drunk drivers may prompt a variety of expectations that will influence their conclusions. Some of these expectations may be surprising. We conducted research in a case with a fact pattern very similar, like virtually identical, with the one I just presented. And some of our research participants who had direct experience with alcoholics and their behavior were more persuaded by the drunk driver's story than were others. Because they believed that heavy drinkers, believed on their experience, heavy drinkers build up a tolerance to alcohol and hence could report what happened more accurately even when they were drunk. We have 3 questions left. Does the story provide an adequate motivation for the actor's behavior? In other words, does the story provide the characters with sufficient motivation to do what they did or to refrain from doing what they did not? We expect heroic motivation to provoke heroic acts. We generally do not expect people to take great risks for minimum rewards. Another question. Is it the only story that fits the facts presented at trial? Obviously, if more than one story can be constructed using the same set of evidence, possibly ordering the evidence set in different logical or temporal sequences, for example, then jurors would perceive no reason to favor one version over the other. Pennington and Hastie agree. If there are multiple coherent explanations for the available evidence, belief in any one of them over the others will be lessened. We confronted such a situation a while back when conducting trial research to determine who might be held liable in a private airplane crash. 4 persons were aboard the plane, all licensed pilots. One of them was a flight instructor who may have been providing advanced instruction for one of the other pilots. Whether the flight instructor occupied the left seat, the pilot's seat, or the right seat, the co-pilot seat, was an important fact in determining who might bear responsibility for the crash. Now, the plane literally flew into a canyon wall, and the crash debris scattered such that it was impossible to tell which person was sitting in which seat in the plane. The plane had taken off from a rural airstrip, hence no flight plan to identify who the pilot was, no contact, radio contact with any tower to indicate who was in charge. And our research task was to determine whether or not potential jurors would resolve the question in any predictable pattern. They didn't. None of the story options were any more persuasive than any of the others. The final question: is the storytelling done by a credible presenter? Jurors must believe the facts that they receive from both advocates and witnesses. Notice I said presenter. I didn't say attorney, advocate, witness. Everybody. Even if the story is factually complete, encompasses all the relevant facts, and is based on behavioral assumptions consistent with jurors' past experiences, it will not be persuasive if they find critical presenters to be non-credible. Credibility, by the way, is a multidimensional construct. It includes, at a minimum, and there may be other judgments and other dimensions involved, it includes, at a minimum, judgments made by the jurors that the presenter is knowledgeable about what he or she is presenting, and that the presenter is trustworthy. That is, that the presenter has the best interests of other people at heart, rather than manipulating them for his or her own personal ends. There you have it. 7 questions that can help us evaluate the extent to which a trial story will be persuasive with jurors. Now, let's consider some implications of using storytelling at trial. Jurors will construct and evaluate their own trial stories even if none are proposed. According to David Ball, lacking a story you provide, jurors will fit your case into a story of their own creation or choosing, and you may not like the fit. I watched how this can happen and then observed the consequences when I served as a juror several years ago. The case involved a dispute between a female police officer and a local physical therapist. The officer had been told that as part of her annual work fitness appraisal, she was required to undergo various tests at a local clinic. One of those tests was to measure her back strength using a device called a dynamometer. To use this device properly, she had to step onto a slightly raised platform, grab a chain attached to a strength meter on the platform with both hands, and pull upward using a continuous motion. While pulling on the chain, she was supposed to keep her spine arched slightly back in a position called lordosis. Now, according to the evidence presented at trial, the officer stepped on the platform, pulled up on the chain, and felt a pop in her back. She reported experiencing immediate pain, and subsequent medical tests confirmed that she had ruptured a disc in her spine. Obviously, the issue in dispute was whether the physical therapist supervising her fitness assessment should be held responsible for the officer's ruptured disc. Now, the plaintiff's story was that the physical therapist had neither properly instructed the officer on how to perform the test, nor adequately supervised her when she attempted it. As a result, when the officer had attempted the back strength test, she had done so with her spine curved forward in a position called kyphosis. The plaintiff offered expert testimony that putting strain on the spine in that position was likely to cause a disc to rupture. The defense's story was that the officer had been unhappy about having been required to undergo the physical assessment, that she had not listened to the PT's instructions, and that once on the dynamometer's platform, she had leaned forward and yanked up on the chain before the therapist had an opportunity to intervene. By so doing, she had performed the test improperly and placed herself in a posture to cause herself injury. The defense also provided expert testimony that spinal discs can rupture at any time, sometimes for routine movements, like bending down to pick up a pencil. So, when the jury began its deliberations, it had two competing stories from which to choose. After some discussion, it became apparent that the majority of the jury members remained unpersuaded by either one. The plaintiff's story that she had been improperly instructed and supervised rested upon her personal testimony. Several of the jurors found her uncredible and her testimony unpersuasive. Likewise, the defense's story, particularly the explanation that spinal discs can rupture almost at will, was not well received. After all, how many of us know people who have ruptured a disc picking up a pencil? Or for that matter, how many of us want to contemplate the possibility we might rupture one of our discs at any time we bend over? So what did the jury do? It created its own story to evaluate. Part of the testimony at trial was that instructions for how to perform the back strength test were posted on the wall of the clinic. Both sides agreed that they were. Neither side raised any issue about either their form or content. They were just acknowledged to be there. Several jury members, however, decided that the adequacy of these instructions must be at the heart of the case. Either they had provided sufficient instruction to the officer about how to perform the test, or they were deficient. The only problem was that because both sides had just acknowledged the instructions' existence and had not discussed them in any detail, the jurors felt they had no way to evaluate them and reach a verdict. The result? I want to guess, 50-50. The jury returned a verdict dividing the fault 50-50 between the parties. There had to be a reason for it. They had the option of saying nobody was at fault. We didn't believe that, but there had to be a reason for it. But it was split down the middle. Of course, this was in Kansas, and the verdict meant that the plaintiff did not recover, and the jurors were well aware of the consequences of that particular verdict. Again, the punchline. Because the jurors found neither side's story persuasive, they created their own, using evidence not in dispute. Jurors will use imposed story structures to fill in factual gaps. Well, this implication underscores one of the storytelling's most major strengths. Case fact sets are never complete. Documents have been lost or discarded. Witnesses have moved or died. Even if witnesses remain, their memories have faded with time. Physical objects were either altered or destroyed. Significant factual gaps will exist even in the best of cases, and jurors will be required to infer their presence when making a verdict. Stories facilitate this inference-making process. Because jurors relate any story they hear or construct at trial with others from their past, they are more willing to infer similar facts they know from past stories and past experience to account for missing evidence. A persuasive trial story provides jurors with a license to make these inferences. Jurors will use imposed story structures to impute and evaluate the character's motivations. Stories inherently involve motivation. The very fact that they structure or order facts in a given sequence suggests the presence of some actor engaging in meaningful behavior. David Ball goes a step further when he contends that stories elicit moral judgments, even stories that neither mention nor ask for. Consider a situation where a female employee has charged her employer with subjecting her to a sexually hostile work environment and then retaliated when she reported the abusive behaviors. At trial, her evidence consists of a series of episodes, relating a series of episodes involving her experiences with her and her direct superior, each one of which she found sexually offensive, up to the point where she reported them to the company's human resources department. After that time, she reported episodes where she was treated differently and singled out from other employees until ultimately she was fired. It is through her and other witnesses relating these episodes that the existence of a sexually hostile work environment must be inferred by the jury. The jury must take into account not only the individual episodes, but also their progressive frequency and intensity. By so doing, the jury can infer the motives of both her superior and the company once she had reported the person's behavior. But let's consider another fact. The employee who filed the complaint did so immediately after being dismissed by her superior. She was not fired from the company. However, as a result of the dismissal, she would have taken an income reduction. Could the jurors use this fact to reorder the episodes, to emphasize different facts, to impose a different story about the events that would focus more on the dismissed employee's motives? Sure. It's all about retaliation. Earlier events in this version become much less relevant. She didn't like being dismissed, and she was trying to get even. What all this suggests is that when you tell the jury a story, even if you focus on the factual aspects of the event, as, by the way, you're expected to do, at least technically, during the opening statement, jurors will infer and will respond to the underlying character motivations that have been implied. Jurors will incorporate technically irrelevant facts into stories and, as a consequence, draw unintended conclusions. Often during trial, evidence will come in that is not germane to the dispute. Jurors, however, will listen to that information, and if it seems useful, incorporate it into their understanding of case events. Again, let me draw my illustration from a trial that took place nearby a few years ago. A mother was driving her two daughters on I-70 for a weekend visit to St. Louis when the passenger side rear tire on her vehicle experienced this catastrophic tread separation. As a result of the blowout, she lost control of the vehicle, and during the resulting crash, one of her daughters was partially ejected and died at the scene. Her lawyer brought suit against the tire manufacturer, claiming that the tire was in a defective condition and unreasonably dangerous when it left the manufacturer's control. In other words, the theory was through strict liability. At trial, the defense called an employee from the plant where the tire was manufactured to testify about the procedures used during the manufacturing process to minimize the possibility that defective tires could be produced. The employee testified that he did not recall being involved with the specific tire's production, and he had no knowledge about its condition when it left the plant. Now, technically, the company employee's testimony was irrelevant for the juror's task of determining whether the tire was in a defective condition when it left the factory. That determination should have been made based on physical analyses of the tire and explanations of the failure process. However, when we interviewed jurors after the jury returned a defense verdict, one commented, "I was smitten with him," the company employee. "He seemed like a normal person. He was very proud of the way they build tires. He was a great witness. I was impressed with him. He was very credible." And another jury summarized the employee's effect, quote, "He wrapped it up and put a bow on it." Clearly, the irrelevant facts that the company employee provided about how tires were manufactured and that employees at the plant cared about the quality of tires they produced influenced jurors' perceptions that the tire could have been defective and unreasonably dangerous. Another implication. trial stories influence jurors' perception of this case scope? When does the story begin? When does it end? Answering that question can be one of the most important issues at trial. Let's refocus our attention on that set of case facts, kind of go back in your mind's eye and remember them, that I gave you at the outset. The story was up here called A Family Tragedy. And let me add just a few additional facts to that set. As it turns out, the lock on the driver's side door disengaged, failed, when the pickup started to roll. When it disengaged, the door opened and Mr. Martin was ejected. The subsequent analysis of the roof and the area where it crushed revealed that several welds between the sheet metal and the frame had been done defectively. The gauge of the sheet metal used for the roof was also evaluated because even though the passenger compartment area in the extended cab model of the truck was greater, the same gauge sheet metal was used for both the regular and extended cab models. Now, including these few new facts create different story possibilities. The family's tragedy could have occurred because the vehicle in which they were riding was either negligently designed or manufactured. With any of the new stories that would come from this process, the scope of the trial story extends back years before the accident occurred. The new story involves relating what happened during the vehicle design process and assesses the motives of all sorts of company representatives, from engineers to designers to marketers. It also, of course, vastly increases the universe of potential facts that must be evaluated and structured. Often a trial is a fundamental dispute between the two sides of what story scope the jury should accept. In this case, the vehicle manufacturer would try to limit the story scope to the accident scene itself. I mean, the family's vehicle was hit by a drunk driver. The driver was at fault. Nothing about the manufacturer was there at that scene. The manufacturer's position would be that it should not even be part of the story. Finally, the juror's story construction process operates independent of any formal rules of evidence, sometimes in contradiction to them. Neil Finnegan argues in his book titled Legal Blame, How Jurors Think and Talk About Accidents, that jurors, at least in accident cases, seek to accomplish what he calls total justice. One of the features of total justice is that jurors want to use all information they deem relevant to their decision. His quote. Whether that information is consistent with what is accepted by the rules of evidence is not their concern. Jurors are active participants in the trial process. They will use whatever information they find relevant. Does it involve hearsay? From the juror's perspective, who cares? We rely on secondhand reports all the time. Does it involve using evidence admitted for a limited purpose beyond the scope of that purpose? Sure, if the information included in the evidence fits in or strengthens the story some way. Does it involve inadmissible evidence? Again, if it helps to make sense out of people's behavior or whether a product was improperly designed, absolutely. The tension between what information jurors want to understand an event, to judge the motivations of how people involved, and from their perspective, the unnecessary limitations placed on them by rules of evidence becomes plainly evident when we consider the role of story or narrative in the courtroom. And it's to that topic that I will return later in the spring.
If folks have questions, please.
Yeah.
In your list of criteria, I noticed that you didn't have anything that explicitly mentioned values. The values come up later in the talk. So does the story cohere with jurors' values about right and wrong, about fairness, and so forth and so on?
No, that's a good point. I'm assuming that stories that contradict your values would also be stories that would contradict your assumptions of how people would behave and their motivations. And so that's you're absolutely correct. And that, remember, I said someplace in there, David Ball says that stories have moral judgments whether you want them to or not. And that is definitely going to be the case. They'll always have them. But we'll wrap them up in terms of the experiences that we have. Yeah.
Have you had a chance to evaluate how judges respond to narrative?
There have been very limited studies, but from the only very limited studies that I know, they do too. They're not immune. They're people. So the answer is yeah. It's a very interesting question because sometimes you will hear. I don't know. I've been playing with an arbitration hearing for a long time, and the interesting thing about the arbitration hearing is that the notion of hearsay comes up all the time. That can we do this? And one of the arbitrators who is a lawyer but not a judge keeps distinguishing between, well, we can understand the effect of hearsay, but jurors couldn't. There's this assumption that somehow or another what they do is going to be different, but the little evidence that I know of says that they're much more like us, other folk.
What do you do with the story if jurors simply refuse to believe? I mean, I guess there's a sort of cognitive dissonance factor and denial that comes into play, it seems to me, sometimes when you observe things. And particularly if you have a really diverse jury, the experiences of the diverse jurors may make it so that the jurors can't accept the same story. I'm thinking, of course, of the O.J. trial where perceptions of what the story was and what was believable and how people put the facts together was dramatically different based on their racial background and experience. Obviously, they weren't all jurors.
Yeah, and that's a good question that, well, usually when we are concerned with constructing a story, we are concerned with constructing a story from one side's perspective. And so our concerns are, can we identify people during voir dire
who are likely to believe.
who are likely not. One of the things I always tell everybody is what you're trying to do is you are trying to find people in voir dire who will refuse to accept the basic premises upon which your story rests. Because if I do not believe that something could possibly happen, it doesn't make any difference how good the evidence is. And so what we will try to do is to figure out how to get rid of them. That obviously didn't happen in the O.J. case, and sometimes it's not going to. In which case, you just have a raucous jury deliberation. That's all you have.
Well, I think you may have just answered the question I was going to ask you, and that's going back to your injured disc story. I mean, what if, in fact, the scientific evidence shows that happens randomly for no apparent reason, but it runs counter to the juror's biased perception that everything has to have a cause? How does one deal with telling a story, say, from the defense side in that case, that you're running up against misconceptions, assuming that's the case, of jurors?
It's difficult. It's very difficult if you're trying to, let me rephrase it in my terms, if you're trying to use the act of God defense, this just happened because she was there. I'm not sure how I would respond to it. I'm not sure that if I were counseling someone, if I were placed in that position, we'd have to figure out some other way of counseling it, because jurors just don't want to believe. In this case, jurors don't want to believe that things happen for no apparent reason, just randomly, or they do bad things in particular. I don't have a good answer for that, because people just generally do not respond well. It's generally not good. It's a difficulty with the defense.
What role does the jury instruction process play into this? You know, when the jury goes in to deliberate, they've heard kind of testimony, obviously, from various witnesses, has seen some evidence and have heard, and they're able to judge the attorneys as well in part of this process. But what about the instructions, and what role does that play, or at all? Or
No, I think it does. Pennington and Hasty, in their full model, talk about the storytelling process, narrative process in court, as really being two separate parts. One is the construction of the narrative, and the second is the fitting of the narrative into whatever legal categories the jury is supposed to use in coming to its verdict. The jury instructions would focus on the second. And so the jury instructions would give the jurors, in essence, the classification criteria that they can use, that they are supposed to use, that they are required to use. Now, of course, part of the problem is that by that time, the jurors have probably already constructed their story. And whether or not the stories they construct are going to coincide with the classification system that they're expected to use is another matter. But nevertheless, what's the jury instruction supposed to do? It's supposed to tell them how to apply the story.
Has your experience shown a difference in general verdicts versus special verdicts, and how jurors construct stories and come up with results, or is that irrelevant to how they?
That's an interesting question, because the general verdict gives them just the ability to go off however they want. We usually see, I haven't really thought about it in those terms specifically, but we usually see that the more structured verdict will force them into that classification process. But again, it's a classification process that has begun after they've already formed the story, and whether or not it fits is something that is much more difficult to figure out. Really, it would be good if, every time you say it would be good for somebody, it would be bad, so let's just say it this way. It might be instructive to try to get the jury instructions at the beginning of the trial as opposed to the end. It would give everybody a sense of where we're going and what we're trying to classify in what way. I hold no hope that that's going to happen, but from this perspective, it would be very helpful.
Do you have any evidence of jurors changing their mind? I mean, jurors who may have begun with a particular narrative. What is the process of getting consensus out of that? Do you have any?
Oh, sure. It's, again, the trial is a cumulative process, and you're getting information, you're getting new information all the time. And as the new information comes in, if at some point the new information just overwhelms the story structure that you've tried to construct, it'll change. This can also happen during jury deliberations. It can occur, but once you've started to develop your own narrative, there's a very strong tendency for you to try to shoehorn everything that you hear, or at least sort of, think about it in terms that you've already started to deal with. That's one reason why I think voir dire, just on a totally different topic outside of this, why I think voir dire and extended voir dire is so absolutely important. Because this is when you can set the expectations of members of the jury, and this is when you can determine whether or not they're likely to be amenable to any story that you're going to tell.
Well, with that, let's thank our speaker once again for